That is present almost in every discipline from 1930.
I want to check it out.
And if you go back.
Okay, I'm ready.
I read large portions of the Encyclopedia Britannica because most people just think it's the Encyclopedia library is right here next to the rule.
That's a state.
Encyclopedia Britannica was special because it was specifically made
Test.
for the biggest
Yep, good.
of the time for the English Society of Science. You know, they read like at Greenwich Village, at the National Observatory, and like you voted in because you're confident and you write a paper, and the whole goal was to turn you down until you know or resolve or improve that it was valid. Like it should be done right. So Encyclopedia Britannica. I'm gonna say how long it persists. But they have descriptions of the firmament, its composition, the distance from the Earth and Antarctica. Yes, in detail. So, in fact,
What solution could be false?
I want to say for sure it's in the 1912.
Is your camera still going? Your video?
No, I turned it off.
You go ahead and start now.
Well, I'm recording on here.
So don't even do your camera.
So you can turn mine off. Leave it
Yeah,
off.
I'm gonna do mine still.
I'm recording on here.
Okay.
This recording is much better.
We're going to start our next presentation. We're going to start here in about 30 seconds, just to let you know. And Glenn is back with us again. He's so gracious to take his time out to visit with us, and he's going to talk about his appeal at the U.S. court, his circuit. He's still fighting. He never gives up. So let's give a big hand for Glenn.
And he shouldn't give up. He shouldn't.
So this is my appeal brief. It's already been filed with the court. And so this is the actual document that was filed, except that, you know, they have requirements like it's supposed to have blue cardstock in the front and then a clear plastic cover and all that crap. So that's not here. But this is the appeal brief. So there's a corporate disclosure statement they want you to have. So if you're a corporation or whatever. So I'm not a corporate slave of any kind. Appellant, okay, I'm the appellant and the wrongdoers are the appellees. So, and this is over that property tax case in Montague County. I've actually, right here, just for golly gee whizzes, this is my petition for writ of certiorari with the Supreme Court. I'm going to do an emergency Rule 11 petition. And so that's the petition. I'm just about done with that, actually. So anyways, this is in the Court of Appeals. I'll file they're trying to get it dismissed right now. And so I don't really care if they dismiss it. There's probably some stuff at the post at the mail that I have to go pick up. We need to get mail here pretty soon. Anyways, there's they've already sent me emails telling me that what they're going to do. They want more time to file their appellee's brief because of what the issues I'm bringing up, and I'm not surprised because I'm saying they're unconstitutional, and it's all over this thing. The appellant fails to be a corporate slave of any kind, including the Pope's slave property, minor estate, 31 CFR 363.6 fiction, called a U.S. citizen, and the appellant has lots of first-hand knowledge of how the Pope's private bar guild scum intend to presume the appellant is dead and lost at sea, in spite of the fact the appellant says he's living on every document filed everywhere, including document 113, affidavit of life, filed on May 30th, 2025 in this case. And then they also want a certificate of interested persons. And so I listed all the liars. And notice here, Christopher Lee Lindsay, assistant attorney with the rank of general, the Pope's Private Bar Guild, Post Office Box, Capitol Station, Austin, Texas. So they're all the Pope's Private Bar Guild, right? And on the mailing labels, I put it on there to the Pope's, anyways. So I like to, I'm just getting up in their face. This guy here is in contact with me right now by email, and he's calling me sir and all sorts of stuff. So I think they respect it, when you bring that stuff up, and you're right. And but they're not going to just roll over. Pamela Bondi, U.S. attorney with the rank of general. I didn't call her that in here.
Have you talked to Edward Martin yet?
Nope, I haven't. Why would I?
Well, I know you said things to him.
No, I have sent stuff to him. Matter of fact, I'm thinking about sending a letter, I filed an amicus on behalf of someone, and I'm thinking about sending it to Trump and telling him, this guy here is the director, he's the Pope's pardon attorney. And he's probably a good pardon attorney because he used to work for Pope John Paul II, okay? So he's actually Trump's pardon attorney. I said the Pope, it's actually Trump's pardon attorney. And he's also the director of Weaponization Working Group. And I sent this amicus curiae, I sent one of them to him. And I'll tell you, these amicus curiaes, they do everything they can to get those out of the courts. They're not interested in justice, okay? The amicus curiae, what it does, we've talked about this before, what it does is it shows that these felony charges they're being charged with under federal statutes, they don't have implementing regulations, and therefore they're void for vagueness. And they try, I filed one on behalf of this guy in Chicago, and they unfiled it. And now they're trying to plea bargain with him, and they're trying to give a plea to something that he's not even charged with. And so, and they're locking him down. They're doing all sorts of crap to him. And so I'm thinking about sending one to Trump and telling him, because I sent a copy to this Edward Martin here. He used to be the attorney for Pope John Paul II. Okay, so he's Trump's pardon attorney, and I'm going to tell Trump that he might be a good pardon attorney, but I'm not sure that he's the great guy for this weaponization working group. You need somebody that's going to really stir up the shit and Department of Justice, because matter of fact, I think Trump could appoint someone that's not even a lawyer in there.
I agree.
Hey, Glenn,
What's that?
I have a question, and I want to make sure I heard you right.
Okay.
Did you say somewhere they are addressing you as sir?
Yeah, that's true. Yeah.
So you're taking a title of nobility?
No.
Have you rebutted that?
It's in an email. Is all it is.
Okay.
It's not anything official.
Okay, because I can tell you in court, they tried very hard to give you a title, and I've had many, like my rank, my being a physician, and then when they got desperate, they tried Mrs., but I was divorced, and so then they tried Miss, but they desperately want to assign that title. So I just was curious when you said that.
In court. Well, that was in an email, as all of us.
Okay.
So, anyways, and you got a good point. I should probably.
And that email actually created a contract of agreement.
I should
You did not
send.
rebut that. You need to rebut that.
That's probably not a bad idea. So, anyways,
Sorry.
that's a good point.
When you said it.
It's these little details that they get you on. Anyways, so he is the. I'm thinking about sending Trump a letter and telling him that this guy is might be a good pardon attorney, but they should have someone else doing the weaponization. They might want to consider, I'm not going to tell Trump what to do, but they might want to consider having someone else in charge of this weaponization working group that's going to stir things up. Anyways, And so then there's an opposition to oral argument. Appellant is not one of the Pope's private bar guild liars. Although the appellants attempted to become acquainted with the relevant law, and as much as appellants not one of the Pope's private bar guild liars, it would be patently unfair to pit the appellant against the Pope's private bar guild liars in oral argument. Therefore, in the interest of fundamental fairness, appellant moves the court to make all rulings based on the pleadings before the court. Should the court determine oral argument in the instant matter will aid the resolution of the matter in order to avoid surprise, appellant moves the court to direct the Pope's private bar guild liars to give prior notice of all law case it intends to bring before the court in oral argument. And then they want a table of contents and a table of authorities. And none of this is considered part of the, see, I'm limited to 30 pages. And if you look, it's actually 36 pages, but none of that stuff up to now is considered part of the appeal brief. And so the appeal brief, and actually there's I could have put a certificate in Microsoft Word. There's a word count. Let's see here. There's a word count thing in here somewhere. Oh, here, word count. So right now, there's 15,005 words in this petition for writ of certiorari. So there's a word count function in Word, and that's one of the things in the rule that says is that if you want to put a statement, if it's more than it has to be below a certain number of words. So you can actually have more than 30 pages, but it has to be below a certain number of words, according to that word count function in Microsoft Word. And but I just filed it like this. I didn't put the statement in there because it's when you consider that none of this stuff applies, and then at the certificate of service, it doesn't apply either. And so, and that's what the last 2 pages are, is a certificate of service. So anyways. Okay, this action in the lower court was initiated because of federal question, your Code of Law for the District of Columbia, Title 28, USC 1331, federal question, because taxation of the land that originated with an act of Congress under Chapter 45, approved August 5th, 1861, and 12 Stat 292, that has not been repealed or modified, and that provided for tax assessors and collectors at 12 Stat 296, required to execute a bond at 12 Stat 296, have an oath of office, Section 11, at 12 Stat 297, Secretary of State, provide for regulations, or no, the Secretary of the Treasury to provide regulations at 12 Stat 297, a direct tax on lands and lots of ground at 12 Stat 297, a Board of Assessors at Section 25 at 12 Stat 300, tax liens at Section 33 at 12 Stat 303. Every collector shall exercise to be guilty of extortion or oppression under this color of this act shall be liable at Section 43 at 12 Stat 307. A penalty for taking a false oath, perjury of oath at Section 47, 12 Stat 308. And there shall be allowed in full compensation for their services, a commission at Section 48. So they get a piece of the action, whatever they collect. So they want to steal your land because they get a piece of it. 12 Stat 308. And see, that's why I say they're nothing but thieves. Diversity of citizenship, your Code of Law for the District of Columbia, 28 USC 1332. Because all the appellees are the Pope's 14th Amendment U.S. citizens as required by Texas civil codes, and under the Commerce Clause, and the appellant fails to be the Pope's 14th Amendment U.S. citizen slave property as described herein. And Congress has exclusive legislative jurisdiction of the Pope's 14th Amendment U.S. citizen property under the Commerce Clause. And that's right here, quoted. And the Pope's 14th Amendment U.S. citizen property under the Commerce Clause. Article 1, Section 8, Clause 3, unalienable rights under your Code of Law for the District of Columbia, Title 28, Section 1343, because appellees are stealing the appellant's land, and the appellant has an unlimited natural right to own land. D, forfeiture under your Code of Law for the District of Columbia, Title 28, 1355, forfeiture because appellees are stealing the appellant's land. Mandamus under your Code of Law for the District of Columbia, Title 28, USC 1361, a petition for a mandamus to order Chad Yarborough, his successor, to do his duty to arrest the appellees for their felonies, and Leah Simonton, or her successor, to do her duty to prosecute the felonies since they have refused to do anything about it, because appellees named herein are engaged in multiple felonies, as evidenced by the 78 criminal complaints filed in the Texas 97th District Court, also filed into the lower court, which the Pope's clergy unfiled. The Pope's clergy in the lower court entered final judgment on 21 February 2025. The notice of appeal filed on 3rd March 2025 within the 60-day time requirement. Court of Appeals is the proper venue to get a void judgment vacated. The minor estate is a fiction of law which originated with the Pope and canon law and a legislative usurpation of the bench, which is a bill of attainder and unconstitutional. The Pope's owned and operated 1871 municipal corporation at 16 Stat 419 and a National Bar Foundation and the Pope's private bar guild, State Bar of Texas, are all unconstitutional. The facts. On 27 September 2021, the appellant converted silver to land in Texas and stated on the bill of exchange, and this is ROA, it stands for Record on Appeal, and that's in the appendix where I have an appendix. It's actually a 500-page appendix. It's 494 pages, and I sent it. I've already sent it out. It cost me it cost me to file the appeal brief. It cost me $500 because it was down to the deadline and I had to get it out, and so I had to send it by second day air. Anyways, have to send 7 copies to the court and then 2 copies to each of the respondents. And the appellant failed to be assessed to K trust, and that's Record on Appeal. The Pope's owned and operated appellees and the Pope's private bar guild members converted the Texas land to the Pope's foreign United States and sent threat letters using their Roman canon law, calling the appellant their slave and threatening to engage in the theft of the appellant's land. On or about 13 June 2022, the appellant served a notice of demand on Catherine Phillips by registered mail, Jennifer Finoglio by registered mail, Clay V. Riddle by registered mail, and Kim Jones by registered mail. True copy of which together approves services attached here to, all of which is incorporated herein by reference in its entirety. And that's Record on Appeal, pages 3 through 21, 256 to 274. So it's actually in there about 4 times because it was attached. What I'm using is some of the motions that I file into the case had attachments. And so it's in there as some of those attachments. And the saying that the appellant failed to be the Roman canon law sesticate trust, but was a living man, explaining the felonies they were engaging in, and a copy of their threat letter enslaving the appellant and under their Roman canon law. The Pope's owner and operator private bar guild and the Pope's clergy in the 97th District Court issued a fake judgment to steal the appellant's land. The Pope's owner and operator private bar guild and conspiracy of the appellees were selling the appellant's land on a tax sale without payment of their extortion. Because the Pope's Federal Bureau of Investigation refused to investigate the felonies in the Pope's County of Montague land thieves in August 2024, the appellant filed the lawsuit in the lower court. On 7 September 2024, the appellant took this matter to a common law jury as evidenced by the finding of facts and conclusions, and that's attached there too. all of which is incorporated herein by reference, and therefore this matter is res judicata by a superior common law court. The Pope's lower court clergy conspired with the appellees to assault the appellant with their canon law minor estate to steal the land. The appellant filed a notice of constitutional challenge, document 10A, on 10 March 2025. The appellant filed document 112, mandatory judicial notice of 12 presumptions, and document 113, affidavit of life, and document 114, notice of void judgment. If we have time, we can go through that. I think it's pretty good. On 18 June 2025, certified copies of each of which are attached to the appendix, all of which are incorporated herein by reference in its entirety. The bar, the 1871 Municipal Corporation, the minor estate argument summary, are all unconstitutional because they come from the Pope. And Article 1 in amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The minor estate and the ruling of the lower court's clergy is a bill of pains and penalties and unconstitutional, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. All argument, all officers of the court have an oath of office to the appellant, as evidenced herein by the statement of original status found in the corporate denial affidavit that's recorded with the Pinal County Recorder at P number 2013-032373, and the pedigree charts that are attached thereto that are now unrebutted truth and public policy, a true copy of which may be viewed at their website. Will Livingston ratify this Constitution for the United States of America on behalf of New Jersey? 1787 is the appellant's fourth great uncle, which means the appellant is posterity, as found in the preamble. And the appellant's entitled to right of blood. And right of blood cannot be destroyed by any civil law because all the laws of Congress and all the laws of Texas are civil laws. The right of blood and kindred cannot be destroyed by any civil law. And this court is operating under a power which is derived from the appellant as posterity. And the maxim says the power which is derived cannot be greater than that from which it is derived. And that's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the appellant to give any of the Pope's appellees or their private bar guild handlers or this court any authority over the appellant, and the legislative Supreme Court of the United States agreed and said it's impossible to confer sovereignty which will extend over the appellant. And this is McCall versus Maryland. The sovereignty of a state extends to everything which exists by its own authority, is introduced by its permission. But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given to the people of a single state. They're not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. The appellant is exempt from the Pope's appellees and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground. There can be no legal right as against the authority that makes the law on which the right depends.
Hey, Glenn?
Yeah.
Can you go back up to that previous paragraph and explain what you're saying about the state and sovereignty?
Sorry, this one here?
Yeah. I
Well-
think it just orally went by me too fast, so.
Sorry?
What are you saying in that paragraph?
Well, I think it speaks for itself. This is McCall versus Maryland. It says the sovereignty of a state extends to everything which exists by its authority or is introduced by its permission.
Right,
So they're talking about taxes, about anything, about their authority.
okay.
But does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? So they're talking about anything that Congress does, okay? Does Congress have power to do anything to the people of the United States?
Got it, okay. I just, like I said, it orally, I was processing all the words, and like the speed of my computer wasn't fast.
We think it demonstrable that it does not.
Yeah, no, that's great. Thank you.
Anyways, so and the appellant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belong to the United States, which is the supreme law in the land. Anything in the constitutional laws of any state to the contrary notwithstanding. Article 6, Clause 2. And that's Constitution. And we, the people, failed to be U.S. citizens because the Pope's 14th Amendment U.S. citizen failed to exist when the Constitution was written. And the Pope's 14th Amendment U.S. citizen is a fiction of law. And the Pope's 14th Amendment U.S. citizen was created by the Pope's canon law by what is now the Pope's owned and operated Congress. And that's the 14th Amendment referred to slavery. Consequently, the only persons embraced by its provision for which Congress was authorized to legislate in the matter were those then in slavery. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, convey real and personal property. And that's current law. That's 42 U.S.C. 1982. Fictions of law were invented by the Roman praetors under canon Roman law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, page 520. Fictions of law. Fictions were invented by the Roman praetors, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fictions owe their origin to the legislative usurpations of the bench. And that's what I say down here. And fictions owe their origins to the legislative usurpations of the bench, which means the fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. A bill of attainder, and that's this U.S. versus Brown, U.S. Supreme Court, which was brought up in the lower court in the demand for relief. Document number starting at ROA 28, document number 103, starting at ROA 152, and document number 104, starting at document number 306, true copies of which are in the appendix, because judges only hold office during good behavior, and judges in bad behavior engage in fraud upon the court. I got to take a little break and run to the little boys' room. I'll be right back.
What about a full man's room?
Sorry?
What about a full man's room?
There you go. An old man's room.
Yeah, there you go.
They said they have a bonds
I think I should go now too, that way.
So they can write the word for you. No, I know what you mean. Financial.
Yeah, they said that. Yeah, on Friday.
Well, it's been years when I just keep digging this stuff out. It's been years since I've read this stuff. And now as I go back and revisit this stuff.
Yeah, I suspect it's created.
Yeah, it's to create more pressure and release resources. And so by the time you get locked up, basically your best defense in the absence of a legal argument is only one of two positions. And that's to discharge your financial control or create a trust, making them the fiduciary for those their reversal.
It's Stanley filed an expression of trust. But clarified it's not assured.
I know, but did you name the trustee?
Yeah.
So I'd have to read it. So, okay, do you say what the purpose of the trust was?
I'm not sure.
So there's like 400 or 500 elements of the trust, and if they weren't completely expressed, then your trust has not been expressed. And so one of the things is the purpose, and the trustee has to hold title to the apartments. And so that means I just would have had to include or sign over the indictment to the clerk of court. Once again, another person out of, and then you know what I'm saying?
Yeah.
So to create a valid trust, you have to have a trustee, a purpose, and a beneficiary. These are the three main systems. Oh, and you have to have, I have better things to do, like, the orders or instructions, all the orders and instructions, those are the four elements you have to have.
You know, I just have so many things to do that I'm mad.
There's no time.
Okay, so therefore the judges in the lower court are the Pope's clergy engaged in fraud upon the court, in conspiracy with the Pope's private bar guild members working for the Pope's County and Montague Corporation. When they issued a bill of pains and penalties against the appellant, named individual, because they intend to be accomplices to the theft of the appellant's land by using the Pope's owned and operated fiction of law, minor estates, Sestike usufruct at 31 CFR 363.6. The Pope's County and Montague Corporation rendered by force the appellant's land, even though the Texas tax code originated after the Civil War with an act defining what money and property is subject to taxation or exemption, and the mode of listing the same, August 21st, 1876. The property be it enacted by the legislature in the state of Texas that all real and personal property in this state, the property of corporations now existing or may hereafter be created, and the property of all banks and banking companies now existing or may hereafter be created. So that's what's taxable. Matter of fact, I sued the Texas comptroller, and they now have an acting controller. So that means the guy that was in there resigned suddenly. And so, we'll see what happens. So, which is for corporate owned property, and in section 4, the term person, whenever used in this act or any other act regulating the assessment and collection of taxes, shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes. Market value means the price at which property would transfer for cash at its or its equivalent under prevailing market conditions. As explained in the Catherine Phillips Notice and Demand, ROA, and that's where it's in the appendix, which was served on the appellees, that shows taxable land is used for the production of income. This is rendition. This is in the Texas Tax Code. Used for the production of income shall render all taxable personal property used for the production of income that the person owns or that the person manages and controls as a fiduciary. And rendition originated with Section 7 of the Act of the Legislature of 1876. All property shall be listed or rendered in the following manner. First, every person of full and sound age being a resident of this state, which means corporate property, which means the appellant's land fails to qualify for rendition, as explained in the notice and demand. It was served on the appellees because income is corporate profits. And this is Eisner versus McComber. And this is like this emphasis, the underlining is in the original, okay? And you don't see that very often. Matter of fact, it's the only place I've seen it. It becomes essential to distinguishing between what is and what is not income according to truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot by legislation alter the Constitution from which it derives its power to legislate, and from which within those limitations alone that power can be unlawfully exercised. Income is derived from the capital, the gain derived from capital. Here we have the essential matter. Not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value severed from the capital, however invested or employed, and coming in being derived, which is derived or drawn by the recipient for a separate use, benefit, and disposal. That is income derived from property. Nothing else answers the description. And so it's corporate profits. The Pope's Bar is an acronym, stands for British Accredited Regency, because the Pope's private bar guild members are appointed by Inns of Court. Inns of Court, a regency is the office or jurisdiction of body of regents, a government authority by regents, the period during which region or body of regents governs. The Pope's private bar guild members are appointed by Inns of Court. These are certain private unincorporated associations in the nature of collegiate houses located in London, invested with the exclusive privilege of calling men to the bar, which is located in the Pope's dependent city-state, located in the city of London, originally called the Kingdom of England and Ireland, now known as United Kingdom and the Crown, since the concessions of England to the Pope, 1213. And this is where King John agreed to pay him 1,000 marks sterling, because King John gave the kingdoms of England and Ireland to the Pope and agreed to rent them back for 1,000 marks sterling per year. And not long after this is Tomlin's Law Dictionary under the definition of Pope. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. Which means all private bar guild members are foreign agents of the Pope, which is why they're here under the Pope's civil laws of Congress, the foundation of the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35 USC 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945. Both judges in the lower court are the Pope's clergy. So let's see what's going on here. Oh, we got some people there. Good, sound is working, good to hear. Oh, let me look here. Okay, well, it's a good thing I checked it. I couldn't really see it on YouTube. I did. Thanks for pointing that out. Appreciate you guys pointing that out on YouTube. I fixed it. Okay, so let's keep going here. If you have any questions on YouTube, put it in all block capital letters. Anyways, and send me a super chat. Both judges in the lower court are the Pope's clergy, private bar guild members, as required by the Pope's civil laws of Congress, called the Code of Law for the District of Columbia, now known as Title 28, U.S. Code, Section 631. The Pope's dependent city-state in the City of London, called the Crown, created the Sestake V Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Pope, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses. That's the Pope, folks. Thus distinguishing between the possession and the use and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Pope, folks. Isn't that convenient, eh? They get to decide whether it's right or wrong. How convenient. to be bound in conscience to account to assess the use for the rents and emoluments of the estate. That's the Pope, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's found in Tomlin's Law Dictionary, Volume 2, under the definition of mort main. And so, who was held by the courts of equity then under the direction of the clergy, the Pope, to be bound in conscience to account to assess the use for the rents and emoluments of the estate, which is under the direction of the Pope's clergy in this case. Okay, so that's right, saying right here that courts of equity are under the Pope. That's the Pope's clergy, which is what the Pope's County of Montag land thieves and the Pope's private bar guild handlers did to the appellant, and which is what precipitated the War of Independence, as evidenced by the costs and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases both affecting both life and property, to supersede the courts of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. Okay, that's Roman law. They're talking about Roman law. They're talking about the Vatican here. And the organic law, the Declaration of Independence, shows it was listed as reasons for the Declaration of Independence from the Pope's tyrant, the Crown of England. He's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged to our laws, giving his assent to their acts of pretended legislation. Who do you think those others are? Would the others be the Pope? Of course they are. For transporting us beyond seas to be tried for pretended offenses. And there's all sorts of stuff in these old law dictionaries that talk about the Pope's pretended jurisdiction. Anyways, for imposing taxes on us without our consent, for depriving us in many cases the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments, turning them from common law into the Roman law, to the Vatican. He's advocated government here by declaring us out of his protection and waging war against us. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, is talking about the Pope's Roman canon ecclesiastical law, which is also why thousands of people were fleeing Europe at the time because of the Pope's tyranny there. And tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of power anyone has in his hands, not for the goods of those who are under it, but under his own private separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness.
Questions. Okay, if we ask you a question.
Okay.
Go ahead.
What I'm hearing is a lot of gobbledygook, terminology, nonsense. But wondering about how this relates to the First Amendment, or does it relate, what you're saying with this court thing, what does it have to do with the Constitution? Are you saying that the Pope has some effect on the Constitution? Where does the Pope come in to the American Constitution? The involvement, is there any involvement at all, any kind, the Pope has over the Constitution?
Well, the First Amendment says Congress shall make no law respecting the establishment of religion. I read that at the very beginning.
Yeah,
And so I'm showing that the Pope is mixed up in all of this crap, and that's unconstitutional.
absolutely. I just wanted to get all the gobbledygook I'm hearing. I wanted to know if that's exactly what it was, which is what it should be.
That's what I'm saying. It's unconstitutional because the Pope is mixed up into it heavily.
and should not be in it at all.
That's right.
And that, yeah, I just
So
wanted.
that, the formation started with the establishment of original
I'm
bank
just
notes.
trying to hear that gobbledygook.
Yeah, it's all
going
based on that.
and You're identifying that as gobbledygook, and it's nothing. Means nothing.
It's unconstitutional.
That's right, it's unconstitutional.
So I have to tell them and say,
Okay.
hold on.
Thank you.
So with the Spanish Inquisition, everybody heard about the Spanish Inquisition, I'm sure. I was over at the Louvre in Paris, and there's a whole wing on the Spanish Inquisition. And the Spanish Inquisition, and an inquisition is one way of proceeding in ecclesiastical court. So it was the Pope that did the Spanish Inquisition. That's exactly what happened. And other inquisitions and oppressions. The use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the Pope's crown. And that's Blackstone's commentaries. Courts ecclesiastical. This is what's going on right now. It says, much oppression have been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. That's what's going on right now. You see that every day in the courts. Canons being subjected to it.
And should not be,
Absolutely, it shouldn't be.
should not be. That's the key.
Which is why the appellant's ancestors made the very first article and amendment, Congress shall make no law respecting an establishment of religion.
Bingo.
After the War of Independence, the Pope's canon Roman ecclesiastical law, Sesticate Ius, was brought into America first with the Pope's 1871 Municipal Corporation. And this is Black's Law Dictionary, 4th edition. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, city has established peculiarly for itself, more properly called municipal law. Okay, so municipal law, Roman law, and Roman civil law are convertible phrases. And then with the Code of Law for the District of Columbia in 1901, the legal estate to be the Sesticate Ius. So that's where they brought that Sesticate V Act of 1666. They brought it into America with the Code of Law for the District of Columbia in 1901. The Pope's minor estate, Sesticate Usufruct, is now codified at 31 CFR 363.6 and are unconstitutional because municipal law was the laws of the municipia or dependent papal ecclesiastical city-states. The appellation of municipal was originally confined to the laws of the municipia or dependent states. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy in the northwest and Naples in the southeast. Area is 17,822 square miles. Population in 1833, 2,742,000. Rome, the capital is Rome. Population of 153,000. Government and elective monarchy. The Pope being the absolute sovereign with a consulting assembly of cardinals. And that's Watterson Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome is the capital of the Pope's territories and of Italy, and anciently the Milrus of the Roman Empire. Roman law is also called canon law. The Roman or civil or canon law, though they are not perhaps to be deemed proper parts of our written law, have undoubtedly had the greatest influence in Scotland. And so that's Encyclopedia Britannica, 1771. The Pope's ecclesiastical city-states were annexed to the Kingdom of England Kingdom of Italy, I should say, in 1870. The formerly Republican leader of southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy, and are now called Vatican City and the Holy See, and it continues to this day. This is the Lateran Pact of 1949. The sovereignty and exclusive jurisdiction over the Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged, and is unconstitutional because Article 1 Amendment, Congress shall make no law respecting an establishment of religion. And the Pope's necromancy, Sestike Usufruct, which is now called the minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor, and a minor can be anyone over the age of 18 years who's failed to take control of the securities in their Treasury direct account. Did you know you have a Treasury direct account, or this estate does? It's actually owned by the you have an interest in it only. Because your parents set it up under, the hospital actually set it up. Anyways, the Pope's Sestike Use minor estate is a fiction of law which is invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. And that's Bouvier's Law Dictionary, 1856 edition, page 520, and the Pope's fictions of law are necromancy and satanic. And this is Deuteronomy 8:10-12, and puts you under the Commerce Clause, violating in Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as made by cession of particular states, and the acceptance of Congress become the seat of government of the United States. To use fraud and deception to assault people with a quasi-contract, a fake contract. A subset, in its origin an action of tort, a subset was soon transformed to an action of contract, becoming afterwards a remedy where there was neither tort nor contract. Based at first only upon an express promise, it was afterwards supported upon an implied promise, or even upon a fictitious promise. And so, introduced as a special manifestation, the action of the case is soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They're contractual in law, but not in fact, being the subject matter of the fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it, which requires the fiction of law, minor estate, constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia, and through their plenary power nationally covers those citizens, even one of the several states, as though the district expands for the purpose of regulating citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, which was why in the Kavanaugh hearings, when they interviewed him for this, when he was being interviewed for a Supreme Court appointment, they asked him, "Can we go after a U.S. citizen in Afghanistan?" And he said, "Yes, you can." And because plenary power is a dictatorship under the Pope's canon law. And so we'll skip all of these except for this one. Plenary power is complete power over a particular area with no limitations. And it's actually in plenary power in the courts of admiralty and English ecclesiastical courts. Okay, this is all plenary. It's a dictatorship. The judges in the lower courts are tyrants, operating as bought and paid for administrative clerks, masquerading as judges. The Pope's clergy, under the Pope's canon law of trusts and bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute's involving the Pope, fake judge is actually a clerk masquerading as a judge, as the Pope's clergy. And when acting to enforce the statute and subsequent amendments of the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administering or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent of the involved agency, but all in a ministerial and not a discretionary capacity. It's the accepted rule, not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency, which means they're legislators, engaging in legislative acts against the appellant and named individual, which is a bill of attainder, a bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment or religion, because it's from the Pope's Roman law, also known as canon law, because they've imposed martial law rule, which is why we took up arms in 1775. And this is cause and necessities for taking up arms 1775. I read that already once. And more recently with the bankruptcy emergency under Roosevelt's New Deal. It's the established fact that the federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments. And as further evidence, the United States federal government exists today in name only. And that's U.S. Congressional Record, March 17, 1993. Since March 9, 1933, notice the date, same date. Since March 9, 1933, the United States has been a state of declared national emergency. Under the powers delegated by these statutes, the president may seize property or organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways, control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought in force by states of national emergency. And that's in U.S. Senate Report number 93-549, dated November 19, 1973. Martial law rule is a law of emergency and necessity. There's three kinds of martial law. Full martial law when actually invaded by a foreign enemy or insurrection, troops put on the street. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martial. And martial law rule is the law of emergency and necessity. It's used during peace times and can go on indefinitely. And that's taken from Ex parte Milligan, U.S. Supreme Court, in the case and the book Non-Ratification of the 14th Amendment by Judge H. L. to the Utah Supreme Court in the case Diet versus Turner. The Pope's private bar guild members will tell you I can do anything I want. And this is, again, taken from that Diet versus Turner and the non-ratification of the 14th Amendment of the Utah Supreme Court. Says this is a war over the intrusion of the civil law upon the common law. The court in Diamond v. Harris calls the civil law statutory law superior equity. And this is a quote from Diamond v. Harris. It's difficult to see how the courts in this state are ignore the common law as a rule of decision when it's made so by statute and adopt the civil law even though it has the merit of superior equity. In the meantime, civil law is a form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And that's what they're talking about in the cause and necessities for taking up arms. It says to supersede the course of common law and instead to publish and order the use and exercise of the law martial. Because normally equity follows common law, which is taken from the Holy Bible. But under martial law, there is no common law, which is also talked about in the causes and necessities for taking up arms, 1775. Every system of law known to civilized society generated from or had as its components one of three well-known systems of ethics, pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It's the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. Which makes it satanic, because the Pope's private bar guild Satanists use the Pope's canon law, capitis diminutio maxima, use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and all family rights. Under the Commerce Clause, Article 1, Section 8, Clause 3, to assault people with their penal action for a breach of quasi-contract. Penal action is an action on a penal statute, an action for recovery of penalty given by statute. When an action is founded entirely upon a statute, the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, okay? So pecuniary, you've got to keep in mind that word. Enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture for non-compliance with an agreement, which is all tied to the Pope's canon law and their quasi-contract pecuniary cause. A pecuniary cause, such as arise either from the withholding of ecclesiastical dues or the doing and neglecting of such act related to the church, whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he is permitted to institute a suit in spiritual court. Such, for instance, are the subtracting and withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy as pensions, mortuaries, compositions, and the like. And that's taken from Blackstone's commentaries on the laws of England. To populate the Pope's prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. And Trump even paid off the Pope when he commuted Roger Stone's penance. Well, I meant sentence. No, penance. It's called penance, which was changed into a sum of money to be applied for pious uses. Penitentiary has meant a penitent or an ordainer of penances, a place for penitence. That's Anderson's Law Dictionary, 1889 edition, under page 764. Penance. So it was Roger Stone's penance is a punishment imposed for a crime by the ecclesiastical laws. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses called commuting. So, and that's book 3 and book 4 of the of Coke's Institutes on the Laws of England. Because of the administrative proceedings under the Pope's canon law, there are more people in prison in America as a percentage of the population than there are in communist China, the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the Pope's private bar guild Satanists selling people into slavery would get their necks stretched. And that's Deuteronomy 24:7. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the Pope and their canon law, so-called courts, which is one of the grievances of the organic law, the Declaration of Independence. He's plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. Why do you think they destroyed the lives of the people? It's because they were selling them into slavery. That's why. All of which has been planned and orchestrated by the Pope. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, May 5th, 1903. The Pope now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman IKEA military staff that's planted on all conquered nations, that's sitting on the right side of the speaker's podium, and the two Roman fascia, bundle of rods bound into weapons, symbolizing under the rule of a single man, that are on the wall of each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers. And there's the picture of the speaker's podium, shows that Roman IKEA military staff right there, and those two Roman fascias on the wall. In God we trust. It makes you wonder what God they're talking about.
3.
Sorry?
It's 3 o'clock, just letting you know.
Okay, well, I'm just about done, so that's good timing. All of which evidences the fact that the 1871 corporation operating in the District of Columbia is the Pope's dependent city-state, and the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state in criminal matters that talks about concurrent jurisdiction of other states, which means other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And here it is, a cite from it. When the same matters are prosecuted in other states, the provisions in force of Vatican city-state on concurrent jurisdiction shall apply. And that's apostolic letter issued motu proprio, entered into force for September 2013, which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's quasi-contract, and the Pope's minor estate. And the Vatican's Pope Francis came and addressed his owned and operated Congress on the 24th of September 2015, and the Pope's satanic private bar guild members are assaulting people like the appellant with their Roman fiction of law, minor estate, sestike usufruct, with presumption of jurisdiction, presumptions of the office of trustee, the minor estate, and presumptions of suretyship. As posterity, the appellant is entitled to common law, not canon or Roman law by right of blood, as described in Article 6, Clause 2 of this Constitution for the United States of America, and is found in the Judiciary Act, 1 Stat 77, saving to suitors in all cases the right to a common law remedy where common law is competent to give it, and in the Judicial Code of 1911, third of all causes of admiralty and maritime jurisdiction, saving to suitors in all cases the right to common law remedy where the common law is competent to give it. Because law of the land phrase is a convertible phrase with common law, and we'll skip this since we're running out of time. And the common law of the land has always been here long before the government was here, and that's found in Hale versus Hinkle, because Pope's maritime codes only apply on the high seas and up to the high water mark of the first bridge of any navigable river. And the District of Columbia or any federal enclave is found in Article 1, Section 8, Clause 17 and 18. The appellant has been very vociferous about being posterity as found in the preamble, and the living man, a living soul, in every document filed into this case, evidencing the prejudgment on behalf of the Pope, its private bar guild members on the bench, the Pope's clergy and their Vatican handlers, because it fails to matter what the appellant says or does. This case was prejudged from the beginning using trust law by the Pope's clergy. The appellant demanded the County of Montague produce a bona fide contract or be guilty of felonies in the Catherine Phillips notice and demand, a true copy of which is attached here to, and they failed to produce any evidence of a bona fide contract, and the Pope's clergy in the lower court failed to produce a contract. It's impossible to prove jurisdiction exists absent a substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting jurisdiction must appear on the record of the court. This court is required to presume that no contract exists. If the court does not show upon the face the facts necessary to give jurisdiction, they'll be presumed not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency and all administrative proceedings. The Pope's clergy in the lower court failed to be an Article 3 court because the appellees in this matter are all the Pope's U.S. citizen, and only an Article 3 court can decide matters involving life, liberty, or property. And this is Justice Thomas. Deprivations or transfer of life, liberty, or property constitute a court of cases that must be resolved by Article 3 courts, not executive administrators dressed up as courts. Where a controversy is such a character as to require the exercise of judicial power defined by Article 3, the jurisdiction thereof can be referred only on courts established by virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer, administrative, or executive board, since they are incapable of receiving it. Therefore, they're acting with no authority and maliciously. The Pope's clergy have ceased to represent the government. The Pope's clergy are deemed to know the law with no immunity. The Pope's clergy, their bill of pains and penalties are unconstitutional acts and a nullity. The Pope's clergy held a kangaroo court. Everything the Pope's clergy did is a fraud and a nullity. Any act to conceal a fraud becomes an act of fraud, and fraud is unexcusable and unpardonable, and any fraud amounts to injustice. And the Pope's bill of pains and penalties, fake judgment, is brutum fulmen. And the Pope's bill of pains and penalties, judgment, is void and an absolute nullity. The Pope's clergy unfiled 78 criminal complaints that the appellant filed into the case in support of the Pope's Federal Bureau of Investigation refusal to investigate them in support of their targetedjustice.com agenda and weaponized Department of Justice, and refused to investigate felonies against targeted individuals like the appellant, and hope that the appellant will exercise his right to resist their unlawful arrest and their unlawful theft of the appellant's land with lethal force if necessary, so they'll have an excuse to murder the appellant and say they killed another sovereign citizen terrorist for their communist handlers, and in support of their war crimes agenda to take reprisals against anyone who think they have rights for their political beliefs, and their communist handlers eliminate private property rights, all of which is in support of the private bar guild and their Vatican handlers, who love satanic blood sacrifices for the Roman cult god Baal so they can pillage the fake money from the Treasury direct account under this minor estate under the Hague Convention concerning the international administration of the estates of deceased persons concluded 2 October 1973. And the appellant is not suicidal, but if the appellant does turn up dead, this is deathbed testimony. The Pope's clergy are priests of Baal and evidently intend to perjure their oaths of office to the supreme law of the land under the Pope's Code of Law for the District of Columbia, now known as United States Code 28 U.S.C. Section 453. And the God they're talking about in their oath is Satan, and they have absolutely no intention of being neutral or unbiased, but prejudged this case from the beginning for bringing the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17, for their Vatican handlers, Sesticate Usufruct minor estate, and it failed to matter what the Pope said or did, because the Pope's clergy intend to sell the appellant into slavery from the beginning in support of their Vatican handlers and the Pope's County of Montague private bar guild buddies, because their oath to Pope's private guild and also their Satan God is the father of all lies. The Pope's clergy are engaged in treason in violation of the Pope's Code of Law for the District of Columbia, 18 U.S.C. 2381, since we were attacked in 2020 by a stolen election and fake pandemic and fake vaccinations, forced medical experiments by the communist Chinese, the Venezuelans, the Cubans, the Vatican, the Serbians, and others. Appellees are giving aid and comfort to the communist enemies in a time of war, because the first plank of the Communist Manifesto is the abolition of private property rights, and the Pope's clergy are busy helping the Pope's County of Montague corporate land thieves with the theft of the appellant's land. The appellant has filed bar grievances against 98 of the Pope's private bar guild clergy some more than once, and they've all been dismissed as an inquiry, and they're all appealed to the Pope's Board of Disciplinary Appeals, and they're dismissed again. The appellant has filed judicial complaints against more than 50 of the Pope's clergy with the State Commission on Judicial Conduct, some more than once, and they've been all dismissed, 25 of them on the same day. The 1871 municipal corporation that's now operating in the District of Columbia is unconstitutional because municipal law is Roman law, which is also called canon law, and it's ecclesiastical for what is now the Vatican. And Article 1 of the amendment says Congress shall make no law respecting an establishment of religion. This is the conclusion. The minor estate, 31 CFR 363.6, says the Pope's municipal corporation, County of Montague, in conspiracy with the Pope's private bar guild and the Pope's State Bar of Texas are assaulting the appellant with is unconstitutional because Article 1 of the amendment, Congress shall make no law respecting an establishment of religion. The Pope's State Bar of Texas, its parent corporation, National Bar Foundation, are unconstitutional because they're owned and operated by the Pope, and all bar members are foreign agents of the Pope as clergy busy assaulting the appellant with the Pope's common law, Roman law, canon law, and ecclesiastical laws are unconstitutional because Article 1 of the amendment says Congress shall make no law respecting an establishment of religion. The judgment and order of the Pope's lower court clergy is a bill of pains and penalties because it's a legislative act that punishes the appellant with the theft of his land without a judicial trial, and the judgment and order of the Pope's clergy buyers and the 97th District Court is also a bill of pains and penalties and are unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The appellant requires an order vacating the void judgment of the Pope's lower court clergy, order the Pope's Federal Bureau of Investigation to investigate the felonies of these County of Montague corporate thieves, and order the Pope's United States Attorney to prosecute the felonies. The appellant requires an order declaring the 1871 municipal corporation unconstitutional, and the minor estate, the National Bar Foundation, and the State Bar of Texas are all unconstitutional. The appellant requires an order dissolving and liquidating the Pope's minor estate, and the appellant fails to care what they do with the fake money in the Treasury direct account. They can put it up their rectal orifice, but the appellant wants it dissolved and liquidated yesterday as a fraud and a lie, and necromancy and satanic can be used to enslave the appellant. And that's the end of it.
All right.
Non-domestic mail without the Pope's United States. Anyways, so that's the end of it. I guess we'll wrap it up here. We're a little bit late. I don't see any questions in the chat. So, yeah, we'll wrap it up. Thanks.